Number 27, the people of the state of New York versus Raymond Crespo. Good afternoon, counsel.
Good afternoon, Your Honor. Stephen Kress on behalf of the people. I'd like to request 2 minutes for rebuttal.
You may, sir.
Thank you. A request to proceed pro se at trial is timely only if it comes before the trial commences. Under the criminal procedure law, a jury trial commences with the selection of the jury. In this case, the defendant asked to represent himself at trial after 11 jurors had been selected and sworn. His request was therefore untimely, and there were no compelling
What's the rule post-McIntyre? When does the trial begin under McIntyre?
The rule is that when does trial begin? McIntyre held that in that case, the trial commenced with the people's opening statement.
So why should we, decades later, not apply our usual rules of stare decisis and follow that same rule?
So, Your Honor, let me clarify. The rule in McIntyre was that a request to proceed pro se has to come before trial commences. And McIntyre held that in that case, the trial started with the opening statement.
Hasn't every case after that said the same?
There have been 4 cases, I believe, that have...
What was special about those cases that made trial start at a different point than other cases?
In the 4 cases post-McIntyre, you're referring to...
Or McIntyre itself?
Well, McIntyre, the trial actually occurred in 1971. At that time, the Code of Criminal Procedure was in place.
So is your argument one of, based on the current statutory scheme?
Correct. The current statutory scheme, the CPL, says that a jury trial commences with the selection of the jury. That's different than what was in place under the Code of Criminal Procedure, which was in effect...
Then why was McIntyre citing the CPL?
It's unclear why McIntyre cited the CPL. I will say this, that even if you assume McIntyre read
So why is it any more clear that the case is about the original code?
That was the very first thing that that McIntyre cited
That's
to.
the order in which it's cited?
It's not just the order, Your Honor. I don't think McIntyre was pulling opening statements out of thin air. That's when the Code of Criminal Procedure said trial began. And in fact...
Wasn't it right on the cusp, kind of, it was 71, and didn't the trial start under the old criminal code, and then the appeal was under the new CPL? Isn't that the way? Because the way Judge Wackler wrote it, it was, like all of his writings, very intelligent, but it seemed to clearly not resolve that problem. It made reference to it, but didn't resolve it. But Judge Rivera refers to I think, an important point, which is, it seems like every court in the state, every jury trial I was on, it's always when the jury's sworn. That's what courts seem to have followed, that rule. It's when they're sworn, and certainly when the opening statements start, that's when the trial begins. It was, I don't recall it. It's been a while since I did criminal work where it began with selection.
Well, Your Honor, we do cite cases in our brief where courts have said that the trial commenced with the start of jury selection. And in fact, we even point out to a statement from this court in People v. Hughes, where the court said that the defendant...
So where do you practice? What county?
We practice in New York County.
New York County. And so when does trial start then?
Trial starts with jury selection. Certainly, when we're writing our briefs and we always say, the defendant proceeded to trial on X date, we use the day that jury selection began.
What moment is jury selection? When does that start?
So I think
when I'm called to jury service and I'm in the room downstairs when they call me to start walking up or take the elevator, is that jury selection? Is it when I'm in the courtroom? When is jury selection?
So let me make 2 points in response, Judge Rivera. The first is that I think CPL 270-15 gives the best indication of when jury selection begins, and the language says that the judge shall initiate examination of the jurors by I believe it says by introducing the parties and giving a brief statement of the case. So the actual language of the statute says the court shall initiate the examination of the jurors. I think that's probably the clearest indication of when jury selection begins.
Why isn't it once you have a jury? There's no jury until you've got the jurors, correct? Otherwise, you're just doing juror selection, no jury.
That's correct, but, I mean, the selection of the jury, I think, refers to the entire process, and that's actually how it's used elsewhere in the CPL.
Aren't the concerns about delay and confusion and that sort of thing, aren't they implicated in, once the process of jury selection starts?
That's absolutely correct, Judge Stein. It absolutely is. And I think this case is a perfect example of that. You had 11 jurors who had been selected and sworn at the time that the defendant made his request. So, and was clear that he was unprepared to go forward with trial at that time. He had absented himself from jury selection, and he kept saying over and over again, I don't know what's going on. So I think at that point,
Well, it's fair to argue that it was the delaying tactic. I think the court recognized that, but the procedural mechanism that you're advocating seems to represent a significant shift.
well, I don't think it would be a significant shift, Your Honor. I just don't think it is. I think
Can the court allow a late request to proceed pro se if the circumstances warranted in a particular case?
yes, absolutely, Judge. In fact, McIntyre says that in compelling circumstances, untimely requests to proceed pro se can be granted. And I know the defendant points out in his brief, while jury selection is often the first time that a defendant will be able to assess how his counsel interacts with the jury. And if you really do have a scenario where all of a sudden the trial strategy changes and the defendant is caught off guard, you can make an application, and in those circumstances could be allowed to proceed.
Are you
pro se.
putting any weight on our decisions, for example, Anton Markey, that say that the jury selection process is very important as part of your argument that trial starts earlier?
Yes, Your Honor. I think since McIntyre, I think you've seen that jury selection has been recognized as a critical part of trial. And I think even some of the commentaries that we cited in our brief actually says jury selection is a critical part of trial. It's recognized as part of trial for other constitutional rights, the right to a jury trial, the right to a public trial, the defendant's right to be present for a material stage of trial. In all of those contexts, jury selection is considered part of the jury trial. There's no
Counsel,
re-
what was the prejudice, what would the prejudice have been if the defendant was permitted to proceed pro se after the jurors had been already voir dire, the 11 jurors?
So, I mean, I think the first one is, you obviously, as I was saying before, I think you would have had a delay in this case, because the defendant seemed unprepared to go to trial, or excuse me, to proceed to represent himself at that point. So, but apart from just delay, what are you going to do with the 11 jurors who had been selected? They were told at the outset that this case was going to take 5 days. So I don't know how much time the defendant would have needed to prepare himself, a week, 2 weeks. What are those jurors supposed to do? Are they held in limbo? It's more likely that they would have been discharged, and we would have just wasted the entire jury selection process up until that point.
Thank you, counsel. Counsel?
Thank you. May it please the court. Ben Schatz for Mr. Crespo.
Counsel, your appellant raises antimarchy and the fact that the court did hold that jury selection is a material part of the trial. What is your response to that?
I think the response is that this court defines trial in different ways for different purposes, depending on the issue. So there's the Steckler case that both parties cite in the brief. There's the Anderson case. And what we're talking about here is governed by McIntyre. McIntyre defined trial to commence on facts very similar to the facts in this case at the prosecutor's opening statement.
Did the court in McIntyre give expressly state a rationale, an analysis of why that particular time was what it considered to be the commencement of trial?
I think you do see that in McIntyre through pages of analysis it undertakes, balancing whether balancing the defendant's interests, the reasons to proceed pro se, the court's interest in maintaining orderly proceedings. The question in McIntyre is, where do we draw this line?
Right. But did they give a rationale for why they chose that place to draw the line.
I think I understand what you're asking. There's no sentence saying that we picked the prosecutor's opening statement because after that point, the trial is in full force, but before not.
So we don't know if it's because that's what the criminal procedure law said at the time, or if it was for some other reason that they picked it.
I think we do know because what McIntyre is doing, and McIntyre is not just any case. McIntyre is the case in the context of the right of a criminal defendant to go pro se. It is one of the greatest cases, if I may say, that this court has issued on this topic. And
Well, it talks about a lot of other factors that went into the
that's
decision.
right. And so there are citations to the CPL. There is a citation to the CCP, and I think what we can glean from that is that the court balanced all these factors and came to the conclusion that the optimal constitutional balance for this issue is struck at allowing a defendant to make a request up to the point when the prosecutor gets up and trial begins in earnest.
And that's certainly a possible conclusion, but can't we also draw the conclusion that the court was faced with at the time of the trial that they were analyzing, that they were considering, that the code was in effect, and it said one thing, and it acknowledged that now, at the time of the decision, the CPL said something different.
I think you have to do some reading into the case to reach that conclusion. I think it's a clever argument. We're in constitutional territory here. The court is obviously not bound on a Sixth Amendment issue to see what the legislature has to say about when trial begins. If the legislature tomorrow decided to amend the definition of trial to say that it starts as early as suppression hearings, obviously a request to proceed pro se wouldn't have to begin earlier.
Isn't it really that if that were the analysis, you would put that right in the case, since you now have the CPL that applies moving forward? You would not have left that kind of ambiguity, uncertainty carrying forward.
That's right. It's a big holding to make in a citation parenthetical, a string citation. I'd like to.
Can you address some of the points, though, that the people raise about the disruptive effect of adhering to what has been decades-old law?
I'm sorry, the disruptive effect
The
with
potential for
respect to
delay and so forth, yes.
Yeah, I acknowledge delay could be a problem. There is no evidence of delay in this case, and I'm saying that recognizing that there were statements made on Rikers Island phone calls where the defendant says, I hope the complainant doesn't show up. Those statements, so the court is aware, were made.
Did the defendant give a reason, a basis for saying that he didn't think his attorney would represent him appropriately?
His reason, and I think this often happens with indigent criminal defendants, they can't get any kind of connection with their lawyer. They are at sea. They feel terribly uncomfortable giving their case to the hands of someone else. And by the time they get to trial, they.
But there's nothing in the record to indicate that that was his reason.
No, and we're not raising a claim that he was entitled to new counsel or anything like that. He said essentially, I don't have a relationship with this guy. I don't feel him, and we're not disputing that those are.
He doesn't bring him any good news.
That is
right?
that is obviously not an acceptable excuse to get a new lawyer. The question is, does he still have this fundamental right to say, you know what? I realize I'm going to jail. I'm gonna go to jail under my own banner rather than.
We're assuming that he has that right. There's no question. Of course, he can say that. The only question is, did he timely assert it? That's all we're really looking at.
His motive doesn't matter.
It's fine.
That's
He has
right.
the right to do that. We all recognize that.
The motive doesn't matter, and I want to address the CPL 1-2011 issue because this court has looked to CPL 1-2011 and decided that the use of the phrase selection of the jury in that provision means when the jury is sworn. And that's the Ayala case, which we cite on page 26 of our brief. Even if we say that what the legislature says about when trial begins governs, Mr. Crespo's request is still timely under Ayala's definition of, or Ayala's interpretation of what CPL 1-20.
Do you think that the
11.
statement is dicta or is a ruling?
I don't think so. Ayala is actually quite similar to the facts of this case. It was a Wade hearing held right before jury selection began, and the court says, Although conducted in close proximity to the commencement of defendant's trial, the Wade hearing was not part of the trial itself, which in defendant's case began only after the jury was sworn, citing
See,
CPL.
The case law hasn't been so clear in it. I thought there were some appellate division decisions under 121 that said the trial commences when jury selection begins in the second department, the two cases in the second department.
I think this is the problem with looking to a legislative definitional term, which isn't intended to focus on these major issues of
But
constitution.
you'd recognize the ambiguity in the interpretation of.
Oh, absolutely. I think that's a big problem with saying we should have a rule that the timeliness, that it's timely up until jury selection, because no one knows what jury selection means. Everyone uses it differently. And right now, we have a beautifully clear rule. It just says when the prosecutor gets up, no more. Trial has begun. And I think that's how courts have interpreted it for the last 40 years. If there are no further questions, I'll rest on my papers. Thank you.
Thank you, counsel. Counsel?
So I'd like to respond to the point about deciding when trial begins based on the purposes of the rule in question. The reason why we ask defendants or require defendants to invoke the right to self-representation before the trial commences is to promote the orderly administration of justice, to minimize delay, avoid inconvenience to the jurors, avoid disruption. Those are the purposes.
But you concede that even if all of those things happen, that a judge could still grant an untimely request.
Yes, a judge could if compelling circumstances are shown. Absolutely, Your Honor. It's not.
And that is, you also concede, because of the constitutional right that's at play.
I think it's absolutely a balancing between the defendant's right to go pro se and the state's interest in the efficiency and administration of justice. Yes, you're trying to balance the two, and I think it's important to give judges discretion in these scenarios where sometimes they're faced with really sort of a lose-lose situation where they either, delay the trial or have to start jury selection all over again. Or if you don't do that, you could be faced with a claim that the defendant was forced to go to trial unprepared and you face reversal on appeal.
But if what is essential here is that constitutional right, and as the defendant is arguing, there's really no opportunity. I want to go back to this issue you were trying to respond to before. There's really no opportunity to have a sense of whether or not you're comfortable with your attorney in trial, not what they've done beforehand, but in trial. The first opportunity for that is at jury selection.
Well, I think you could say the first opportunity to see your lawyer, do a summation is at summation, but that doesn't mean that you can go pro se at that point.
But it's at that moment, at the jury selection, that you're seeing, you're observing the way that counsel interacts in that room and what, if any, sway they may have over these people who are going to decide the defendant's liberty interests and their future. And you will concede that most defendants don't get a lot of time with their lawyer, correct?
I don't know if I want to make a general statement about that, but if in fact, you go to jury selection and you see your lawyer for the first time and you realize, oh, wow, this guy's terrible, or wow, he's not.
Or female, yeah.
Or, excuse me, this attorney is terrible and he or she is not representing me the way that I want to, and you can make that case to the judge has discretion to allow an untimely request in those circumstances. So if you say that jury selection or that trial begins with at the start of jury selection, you're not saying.
So then at that point, the judge is going to ask, how many times have you talked to your lawyer? How many times have you seen your lawyer?
The judge can do an inquiry, exactly, and the defendant can make the case as to why at that point he should be allowed to go pro se and can explain, why the concerns underlying the timeliness requirement wouldn't be present in this particular case.
Thank you, counsel.